Ready? Start. The standardization of addition to income for future prospects shall help in achieving certainty in arriving at appropriate compensation. Stop. We approve the method that an addition of 50% of actual salary be made to the actual salary income of the deceased towards future prospects where the deceased had a permanent job and was below 40 years, and the addition should be only 30% if the age of the deceased was 40 to 50 years, and no addition should be made where the age of the deceased is more than 50 years. Stop. Where the annual income is in the taxable range, the actual salary shall mean actual salary less tax. Stop. In the cases where the deceased was self-employed or was on a fixed salary without provision for annual increments, the actual income at the time of death without any addition to income for future prospects will be appropriate. Stop. A departure from the above principle can only be justified in extraordinary circumstances and very exceptional cases. Stop para. Be it noted, though the decision was rendered at earlier point of time, as is clear, the same has not been noticed, and that is why divergent opinions have been expressed. Stop. We are of the considered opinion that as regards the manner of addition of income of future prospects, there should be an authoritative pronouncement. Stop. Therefore, we think it appropriate to refer the matter to a larger bench. Stop. Now the question is, which is the judgments ought to be followed, awaiting answer to the reference made by the Supreme Court. Stop. Having carefully considered the submissions made by the learned senior counsel for the parties, and having examined the law laid down by the Constitution benches in the above said decisions. Stop. The law laid down by this court in a decision delivered by a bench of larger strength is binding on any subsequent bench of lesser or co-equal strength. Stop. A bench of lesser quorum cannot disagree or dissent from the view of the law taken by a bench of larger quorum. Stop. In case of doubt, all that the bench of lesser quorum can do is to invite the attention of the Chief Justice and request for the matter being placed for hearing before a bench of larger quorum than the bench whose decision has come up for consideration. Stop. It will be open only for a bench of co-equal strength to express an opinion doubting the correctness of the view taken by the earlier bench of co-equal strength, whereupon the matter may be placed for hearing before a bench consisting of a quorum larger than the one which pronounced the decision, laying down the law the correctness of which is doubted. Stop. Pending applications, if any, stand disposed of. Stop.